Juror number 4, I see you have some papers. Are you the foreperson?
Yes, I am.
Has the jury reached a verdict?
Yes, we have.
And is the verdict the unanimous verdict of all jurors?
Yes, it is.
I'm going to have you hand the verdict to the court attendant. I will now read the verdict of the jury. In the matter captioned State of Iowa versus McKinley Louisma, FECR 153477. Count 1, we, the jury, find the defendant guilty of murder in the first degree. Count 2, we, the jury, find the defendant guilty of kidnapping in the first degree. Count 3, we, the jury, find the defendant guilty of conspiracy to commit a forcible felony. Signed by the foreperson. Would the state like the jury polled?
Yes, Your Honor.
Jurors, I'm now going to poll you individually. I'll do that by juror number. And I'm going to start in the top left-hand corner of the jury box. I've just read the jury's verdict, and I'll ask each of you if this is your true and correct verdict. Juror number 1, is this your true and correct verdict? Juror number 2, is this your true and correct verdict? Juror number 3, is this your true and correct verdict? Juror number 4, is this your true and correct verdict?
Yes, it is.
Juror number 5, is this your true and correct verdict?
Yes.
Juror number 6, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
Yes.
Juror number 8, is this your true and correct verdict?
Yes.
Juror number 9, is this your true and correct verdict?
Yes.
Juror number 12, is this your true and correct verdict?
Yes.
Juror number 13, is this your true and correct verdict?
Yes, it is.
Juror number 14, is this your true and correct verdict?
Yes.
Is there any record with regard to the polling of jurors from the state,
No, Your Honor.
from the defense?
No, Your Honor.
All right, jurors, I'm now going to release you with the thanks of the court for your service here during this trial. At this time, you'll return to the juror room, and then I'll be in to speak with you in just a few moments. Thank you very much. And then sentencing is set for December 6th at 1:30 p.m. Mr. Louisma, you have the right to file a motion to arrest of judgment and or a motion for new trial. If you choose to file either or both of these motions, you must do so no later than 45 days from today's date and no less than 5 days before the date set for sentencing. You can talk to your attorneys to learn more about these possible motions. Do you understand that right? Because the defendant has been found guilty of committing non-bailable offenses, the right to post any bond is revoked. Any final record from the state?
No, Your Honor.
From the defense?
Yes, Your Honor. I filed proposed exhibit defendants A, which I propose as a court exhibit. It is a 27-page PDF of Mr. Moore's closing argument that was published for the jury, with the exception of pages 26 and 27. They were not shown to the jury. I'd ask that the court accept that. I would ask that the state do the same with its closing argument PowerPoint.
What was the number again?
Letter, actually. It was defendant's exhibit A.
And that's just as a court exhibit?
Yes.
And is the state willing to do the same?
the state's PowerPoint did not just have pictures in it, there were videos embedded in it as well, so I don't know how we would do that. And given the fact that there were no objections made at the time, the PowerPoint was on the screen, then I don't see, I guess, a basis or a need for us to do that. But of course, we'll follow the court's guidance.
Is it contained in a single PowerPoint?
I would say it's, yes, a PowerPoint file, but I can't turn it into a PDF that would accurately represent the PowerPoint.
And I understand that concern, and from defense counsel, given that I didn't give that direction before, I don't know how they would load that in a form that I can preserve for the record, at least in EDMS. How would you suggest that be done, understanding the desire to have it?
I would request that it be put on a flash drive, and that flash drive be a court exhibit.
I mean, that's fine as long as it's understood that it would just be a PowerPoint. In other words, I'm not going to ask the state to produce it in a different form.
No, that's fine.
All right. I'm going to go ahead and do that. I have had direction from the appellate court that that be done if requested, simply so that there's a record of what was displayed to the jury. But I'm not going to ask the state to produce it in a different form than was actually utilized. And so if you would simply provide that on a separate flash drive with the PowerPoint and mark it as State's Exhibit 1, and it'll be received as a court exhibit. So it'll be court exhibit closing argument PowerPoint.
Would that confuse in any way with State's Exhibit Actual 1?
If you call.
Okay.
Any further record?
No, thank you.
All right, this record is closed. Thank you.
They could be referencing.
They would be.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof.